here today. We're delighted that you could come and make use of our wonderful facility. We understand from scuttlebutt that we hear that the undergrads, when they have their mass migration over here during exam week, say to their colleagues and friends, "I'm going over to the tree house." So it's a very pastoral setting, appropriate for a theology library. I'd like to just cover a couple of logistics for you, and then I'm going to get out of the way. You may have noticed already, as you go through the door here to the left, there are restrooms. Those are pretty much yours for the day. I don't think anyone else will be coming downstairs, so they're yours. In fact, you guys are pretty much taking over the building. During your lunch and then the breakout sessions, we have classroom space that is reserved for you. 2 different rooms on this floor, and if necessary, a room on our top floor as well. I think those are the only logistics that I need to... Oh, one more thing. We want to keep the doors closed near the food because the Brighton campus has very brazen squirrels. And I have actually seen a squirrel climb up on the food table in a prior event, so we want to keep those closed when you're in here. Thank you. I hope you have a wonderful day. And Margaret Cohen is going to speak to you.
I think that's the part of having a building in the treehouse. You get the squirrels as well. It comes with the territory. I'm Margaret Cohen. I'm head of Educational Initiatives and Research Services here at Boston College. And also I'm chair of the Library Accessibility Committee. So I too welcome you here to the Brighton campus at Boston College in the Theology and Ministry Library. Media access refers to the digital, the web, and the broadcast content that can be used, read, and viewed by users who are, for all users, and especially users with disabilities, particularly those who are blind or vision impaired, deaf or hearing impaired, or anyone with a cognitive condition or mobility disability. Accessibility for individuals with disabilities is an important topic and an important issue in both libraries and institutions. We must understand the legal requirements, the guidelines, and the standards which we must apply in our institutions, as well as understand the needs of our users. Additionally, we have to consider accessibility as it pertains to student engagement with content, with the physical and the online environment, as well as providing services, looking at vendor products, and so much more. So I'm really delighted today that the Boston Library Consortium has put this program together. I am going to turn it over to Gabe to go over the logistics of the day, but I certainly hope that you enjoy your time here at Boston College. Thank you.
Good morning, everyone. My name is Gabe Stetson from UMass Amherst, and I just want to welcome you all to our day. This is the Boston Library Consortium Streaming Media Community of Interest Day. Bit of a mouthful. But we're really glad that you're here. We, of course, want to thank Susan Stearns, who could not be here today, recovering from foot surgery, but we want to thank her for everything that she does for the Boston Library Consortium. I'd also like to thank Jessica Harden for doing all of our logistics and planning and helping us out, keeping us organized and on task for the whole process of organizing this event, which you'd be surprised probably we started in October probably. So we're glad that it's finally here and we're ready to get going. I also want to thank my fellow co-planners, Deborah Mandel from Northeastern, Amy Howard from here at Boston College. We have a full day today. We're very excited for all the things we have to show and talk about. As I said, it is kind of full. We're going to try to get through things as fast as possible. We don't have a ton of breaks in between. I'm sure if you can step out for a second, it's perfectly fine. We're going to be focusing on several areas today. The first will be a panel of, focusing on defining the media accessibility, specifically focusing on legal standards. We also have some best practices at other BLC institutions. We'll take a quick break for lunch. We have representatives from service platforms and products. And then finally we have streaming media content vendors, people who have databases that we'll be talking about their accessibility and what they can provide to us. At the end of the day, at 3:15, we're going to have time for discussion, coffee for the road. If you guys are interested in talking to the vendors, they'll have tabling set up. You guys are more than welcome to hang out. We're all set with parking for the day, so hopefully your cars won't get tickets. Amy's worked to make sure that won't happen. And with that, I think I'll introduce our first presenters. I will say really quickly that Laura Quilter, coming from UMass Amherst, is running late. She should be here hopefully in a few minutes, but I think we're going to go ahead and get Kyle Courtney, Copyright Advisor at Harvard University, and Carly Spina, Head Librarian Assessment and Outreach here at Boston College.
We'll leave a spot for Laura.
Yes.
Thanks.
Here you go.
Sure.
Did you want me to pull up the questions that you were provided with, or you're going to go through them?
We got him here.
So Susan Stearns was the person who was originally kind of convening this panel. Developed some questions that she wanted to focus on, and so I'll turn it over to you guys, and hopefully Laura will interrupt us as soon as she does. All right.
We're starting a little early, so that's always good for comments. Thanks for everyone. Welcome to see you. Our task today is rather large. This is an area that we've all dealt with in some kind. It's a complex network of best practices, regulations, statutes, and often litigation. And sometimes not even the end of litigation, sometimes settlement. And so we thought we'd go over some of these today, what's developed in the standards, but I think our first defining question, again, Carly and I didn't pick these questions. These were the questions that were gathered from the community at large. So what do we mean when we talk about streaming media access? That's a large chunk of what we do here today, but obviously the streaming media is the media that is temporarily cached in your system, but not permanently archived in your computer. That doesn't create a permanent record of the material. It's fed to you bit by bit. And so most of the time you can't make a permanent copy of it. Am I right about this?
Well, usually based on terms of service. There's always a way to do everything.
Of course, there's a way to hack it and keep it. Yes, we can probably download YouTube somehow. But
But usually it refers to stuff that is hosted someplace else and you can access it, which can be useful for copyright purposes because it does allow you to provide more restrictions on how it's used and how it is or is not reshared.
Sure.
So it means that you can limit it just to people who are in a class, for example, more easily.
sure, and it's a compressed file, and that it gets decompressed in your code, and then it doesn't necessarily permanently exist. And a lot of our services do that, right? So we have music, we have movies, we have documentaries, we have the major streaming, Hulu, Comcast, etc. We all don't have permanent copies of them. And again, copyright's out of the house, absolutely. So that's kind of how we're defining what that is. Now the larger. What are the relevant laws in the U.S. we should be aware of? I think you should be aware of every law in the United States for which you could be subject to, but I guess for the purpose of this, we had to narrow it slightly. We started off with the big federal requirements first, and then we're going to boil down to some of the cases that interpret that over time. But first of all is the ADA. I'm sure it's not a surprise that we would bring that up. This is the law, written in 1990, that is about as broad as possible. Now this is for people with disabilities, which is defined differently.
Yeah, the definition of people with disabilities is specific to the law. It's pretty much what you would expect, but it does mean that if you're planning to do something You might want to check in. Most institutions that you work at probably have offices that deal with these sorts of things, and see how they determine who's eligible for certain benefits and such things, because that will be relevant for some of the laws we talk about later. Sometimes you need to have someone that you've actually determined has a relevant disability in order to be able to provide services. But under the ADA, another thing just to sort of note is that there is some protection also for people who are thought to have disabilities, though I don't know that that's necessarily come up in the context of streaming media ever. It is an interesting note about how it's not defined quite as you would expect.
Sure. So, and another thing, this, as I said, I want to make this note. This was written in 1990. The World Wide Web didn't become fully accessible to us until 1991. So the concept here that this was neither streaming media nor the internet as we know it today existed. The internet evolved, so the needs for this law to also evolve has come, and that's where we see courts often evolve the law for it. But 1 in 5 Americans has a disability, and this was a real troublesome thing. The ADA was supposed to fix this, but we did not predict, probably, and no one would predict that the internet would become such a presence in our lives, every aspect of education. So you have to maybe forgive Congress for writing a statute at the time period, which was a snapshot. So interpretation of this, I think, is pretty important. So with regards to, go ahead.
I was going to say, another point of it is that the population, specifically since many of us are in higher education, the population of people with disabilities in higher education has also been increasing for a variety of different reasons, including because of successes with the ADA and other laws in lower, K through 12 education, means that it's made a lot of strides towards more people with disabilities going into higher ed institutions. So those numbers keep increasing.
Yes. So we think that Title II and III of the ADA are the ones that really hone in on the web accessibility and need for closed captioning. Now, Title II is specific for public entities. So this is both, by the way, it's not just federal, it's at the local and state level as well. Any government organizations must ensure, the quote is, effective communication with citizens, including providing assistive technology or services as needed. Title II is critical to this, and the idea is that if you receive federal funding, if you touch the government in some capacity, Title II could be applied to you. Even though you may not be an actual government organization, there's been broad interpretation of that by the courts. So that's Title II. Title III is the places of public accommodation. Carly, is the library a place of public accommodation?
Well, I'm always going to say that. But it might depend in certain situations, certainly. I mean, it's going to be a spectrum, but I would say that for most of the institutions that do allow access to their libraries to anybody who walks in the door, which is different from institution to institution, but I would say at a minimum, if you allow that, then you should assume that that is the case. Also, there have been some questions about, and I don't think it's fully settled, but we'll talk about some cases about whether a website is part of that as well. So even if you don't allow people in the door, you might want to consider about the content you're putting on the web.
And so any videos produced by even your hotel, your movie theater, etc., are supposed to be captioned in this light of thing. And this is, I actually checked this when if you're at a conference this time, you're in the conference hotel, turn on the conference hotel channel, and see if it's captions, because they're supposed to actually do that. Not just for the specialized rooms, it's supposed to be for everyone. So we're dealing with Title II and Title III. I would also be remiss if we didn't mention 508 and 504. This is the Rehabilitation Act. Now, this deals more with websites, at least in the way that we've been talking about it today, and streaming media would fall under here. Closed captions are a very specific requirement of Section 508 of this Rehabilitation Act. And 504 is specialized for federal entities, or, again, organizations that receive federal funding, which many of us do in some capacity. And this means maybe we should consider closed captioning there for those that fall under the standard. Now, there are a ton of other, by the way. We picked those because those were the top ones that have been interpreted by the courts. But there's also the Film Captioning Act, the IDEA. There's a number of other statutes that affect captioning and disclosure, but we were focusing only on streaming media here in an academic environment. But there's a patchwork of other laws that affect captioning as well.
And one of the areas where there's a slight gap is in exactly what's required of the captions.
Mhm.
And so, what level of accuracy comes up sometimes, placement on the screen is a question sometimes, and for those, I usually recommend to people that they look to the FCC rules. They aren't necessarily, I don't think any court has said you have to follow the FCC rules, but it's definitely something that they do require for television shows, and so it gives you a framework to think about at least what might be a good starting place.
Absolutely, lessons we've learned from what the film industry has to do, what the television industry has to do, with the FCC mandates can make great best practices. so to
Exactly.
speak. Where they say something like 90% of your captioning needs to be spelled.
Oh, I think it's actually higher.
Is it higher than 90? I
Has
thought
to
it was
be
90
accurate.
has to be, or 90, 95 has to be spelled right. That would just make sense though for the requirements.
And you can find some things online where people show what happens once you get below that level. Like they'll actually do things that fall below that level, and you'll see how quickly it becomes really incomprehensible. Like it sounds like 90% is so high,
Yeah.
but once it's interspersed with everything, it quickly becomes very difficult to understand
Yeah.
what's being conveyed.
Again, so those are the larger structures of the law, the big federal laws that encounter a lot of what we concern to as streaming here, but we also want to mention the Chafee Amendment. This was, I just did a legislative history of this. This was almost part of the act that governs libraries and archives. Back when it was first introduced, it was introduced as a section 108, just later moved to another section. But it was almost within our wheelhouse as libraries to take care of this specific thing. And it passed by voice vote in 1996. This was not a big deal. And it said, notwithstanding the provisions of section 106, in case you're wondering, section 106 is the bundle of copyright. So it says, notwithstanding the copyright holder's rights, it's not an infringement for an authorized entity, such as libraries, to distribute copies, specifically for people who are blind or other people with disabilities. And here comes a copyright expert right now.
Fresh from traffic.
Fresh from traffic. Laura, we just heard about the Chafee Amendment. So this is a powerful statute. If you look at this, this says, hey, despite the fact that the publishers might own the copyright on the textbooks, on the articles, etc., you as an authorized entity can make that copy. It's an exception, a powerful one to that. And again, this passed by voice vote. This was not a big deal in Congress at all when this first passed. So the question, however, that I always got is, what is an authorized entity? What is the capability of libraries to do this? And of course, I always think we are, clearly. If they define it as a nonprofit organization or a governmental agency that has a primary mission to provide specialized services for training, education, adaptive reading, or information access needs of blind or other persons with disabilities, that's pretty much a library, right? We're about as close to that as possible. There's been no strict interpretation of that I've seen, but most library units, it seems, are involved.
Educational and
Yeah.
public libraries.
Yeah. Of course, you mentioned the on-campus Office of Disability.
Right, yeah.
Certainly, they're an authorized entity that can give us the nod to start making stuff available with captioning, et cetera. But I'd say libraries can do it on their own.
I do too.
I think libraries can do it on their own. There was argumentation for a while, right, from the rights holder side.
Yes.
You had to be like the National Library of the Blind,
Mm-hmm.
a couple of these things. But I think we have moved past that. I don't even think they try to make those arguments these days. They've given up.
Yeah, they have. So that's an important aspect of it.
I do think it's worth going, can we go back to the
We can go back.
Just for people who maybe are in the English literature side of things, that it does have
Yes.
an odd little carve out for non-dramatic literary work.
Strangest comment.
So I'm not really sure. So I guess if you have a dramatic literary work, which I'm not sure why that's there, but it's just something to keep in mind if you are thinking about something where we'd be reproducing plays, for example.
Yes.
Although if we get the Marrakesh.
We're getting
that
there.
will fix it.
Yeah.
Absolutely. So authorized entities, that's us. Blind or other people with disabilities, print instruction materials in specialized formats. These are other things that are defined inside the Act. What they end up doing, and the only reason I show this law, you don't have to copy this or remember this, is that they often borrow from other acts which have used or defined disabilities, or use or define specific terms. And that kind of, as I said, it's a patchwork and a weave of different types of federal legislation. This kind of ties that together. So they're using blind in accordance with the 2 USC 135, using print instructional materials as defined in Individual with Disability Acts. This is how they bind all these together and make it understandable to the masses, and it also prevents them from rewriting every single time what we mean by print instructional materials.
And
I think that's helpful.
I think it's worth just noting for people who might not think of it automatically what Margaret said at the beginning, which is that it's not just blind, it's people with print disabilities as well, which can actually be fairly broad. That can be things like mobility impairments that make it impossible to use a print book. It can be things like certain types of cognitive disabilities. So just keep that in mind, that it doesn't necessarily have to be someone who has a visual impairment.
Absolutely. Who likes the Google Books case? Everyone here should say yes.
Yeah.
I just point this out because in this case, the decision said, well, print disability is anything that Carly just described. And they actually went into the legislative history and said, this is actually what we mean is a fair use. Now, of course, they wouldn't go by unless I mentioned fair use at least once. And this is my opportunity today. Again, in the legislative history, they said, hey, this is exactly within the wheelhouse of what we should be doing, and it's fair for us to do this. Despite Chafee Amendment, despite this other stuff, it's making things accessible to others could be covered under fair use. Could be. But that's to be decided. Now, some countries don't have what we have with regards to Title II, Title III, IDEA, Rehabilitation Act, and certainly not with regards to Chafee Amendment either. Some places it's illegal to do what we do here in the States, and I think that's kind of a shocker. But Kenny Cruz and other folks that have worked with WIPO, they came out with that report that said fewer than half of WIPO's 184 states had a specific copyright exception or limitation to help the visually impaired, including ideas about captioning, accessible formats, and even if you were capable of doing that, you couldn't share it with another country. So that's a big problem, right? So this is not just the US-based problem. This is kind of that problem for all the world to not be able to, A, make things accessible and caption right, and then B, share it across a border. Except, you know, hopefully in the next couple of days, we have this Marrakesh Treaty. Has anyone heard of the Marrakesh Treaty? Has it been all right, yeah, a couple people? So Marrakesh is the first user rights treaty that I could think of.
In copyright.
Yes, in copyright, sorry. Specifically, that says, well, this is a worldwide problem. And if we have an international treaty that says the same things almost that the Chafee Amendment reports, wouldn't that be a lot better and prevent this vacuum of people that cannot get captioning, accessibility formats everywhere in the world, as long as your country ratifies this law. And we're up to a high number of ratifications, right?
Yeah, I don't know what number we're at right now, but it's quite a few countries have already done it. And earlier this month, the first transfer was actually done by 2 signatories from Canada, represented by University of Toronto and EIFL, to Kyrgyzstan. 2 people had asked for materials and they transferred them. It was the first case that they actually made use of this provision, so it's already starting to help.
Now, again, this is another thing that you gotta use that sort of authorized entity language that we saw in the Chafee Amendment, and clearly we think libraries fall into this definition. Any educational institution will fall into this definition. So this is taking a basic law and making it an international law, which is usually good. Now, it's on its way to being ratified here in the States.
Sure.
It's in the Senate. It's in the Senate because, as you all know, international treaties, maybe you don't know, are conferred upon the Senate to give the president the official nod that it's okay upon their
Ratification.
ratification. Yes.
And they're passing they've introduced a package to do implementing legislation. And that's basically going pretty well.
Yep, and that is going to be 121A. Which is this new provision. And so that's how international law generally works, right? You pass a big treaty, and then they say, okay, implement this at the national level. And this is not just an update of what we looked at the Chafee Amendment, it's new. It has new clauses, it has new requirements. And and I think it's actually something good emerging from Congress.
There are a couple of pieces of copyright legislation moving through Congress right now, but
Yes.
this one is on the faster track, so it looks like we might actually get this one. And do you want to talk about like some of the specific things in it, or should?
Yeah, we can, if
Do
you'd
wanna do
like
that
to,
later?
please, absolutely, because it's an important new treaty.
Yeah, so, I mean, it will enable the international lending of materials, which has been kind of a problem for us. So if you make materials accessible, if you have accessible materials, you'll be able to lend them internationally. And it shifts some of the, you know, the sort of weird restrictions we have. So I think we'll be able to do sheet music now, right?
Yeah.
And scores and,
Yeah.
and the dramatic works, right?
Yes, that non-dramatic thing is
I feel like
eliminated.
I feel like I'm missing one of the other categories that get added in with Marrakesh. But
That's good enough.
yeah, it'll loosen up some of those requirements and actually create a lot of accessibility. And this will be really good because in the US we have a large reservoir of accessible materials, or we're a lot of capacity of making materials accessible, right? Even though we all know that we're not where we should be, we're way better than a lot of other places. And so we'll be able to source a lot of places in the world. And then similarly, we'll be able to get materials from those places in accessible formats, whereas before people were just like, I don't know, do I have to send the hard copy and let them make it, you know, make it accessible? No, now you'll be able to make an accessible copy and send it out. And I think, actually, you know, you'll also be able to make the accessible copy, you'll be able to keep the accessible version, right? So you won't have to keep redoing it, right? So that will be really helpful.
Yeah, especially, and I was thinking about when captioning gets done overseas and be sent here for once instead of us always having to do it, that would be kind of a nice benefit.
Yeah.
You know, because it's always on the library to make the captions or make the scans or make it available. Let someone else do it and send it to us, that's nice. So, that's our kind of law overview. Now, there's another large question. Who made these questions? Are there specific regulations, legal standards, and guidelines that are important for the academic libraries to consider? Yeah, yes. So we mentioned earlier the FCC's
Yeah.
requirements for captioning. It's clearly administrative, regulatory function, and it would behoove us to read and know what they think is the bare minimum for proper captioning. Right? So that would be a good. The Film Captioning Act does the exact same thing for Hollywood movies, right? What do they have to meet? That's a federal law. What do they have to meet for captioning requirements for the public at large in movie theaters? That would be another kind of good standard to read and know.
Not a legal standard, but people are familiar with probably WCAG.
Yep.
And probably in the next few months, they're going to be releasing WCAG 2.1, which is going to have even more to say about
Why don't you
some of
explain what that
these.
is? For
Okay, so WCAG is standards that are put forth for website accessibility, well, web accessibility, anything that's online, basically online accessibility. It's an act, well, it's WCAG, so I don't even remember what that stands for.
Web content.
Yeah, I've been saying WCAG for so long, I forgot what it is.
And right now we're at 2.0, which has some information that's relevant to this sorts of stuff, and has a lot of things, like probably anybody who works on websites is familiar with it. It's got 3 levels. You're either compliant to level A, AA, or AAA, and with A being the least and AAA being the highest level of compliance, most accessible. And what's interesting is this summer they're coming out with an addition to it. It's not going to get rid of or change anything that exists, but it's an addition called that's 2.1, and that's going to have some provisions that deal with online media. So it's going to probably have some more guidelines around making video content accessible, for example.
So that would be a big one. So we went through Title II, Title III, 504 rehabilitation, 508 rehabilitation, FCC guidelines. By the way, are you writing all these down?
I think part of the problem is that a lot of legal
And
standards
also-
come out of, or best practices come out of court cases.
Yes.
And in terms of best practices, a lot also come out of settlements.
Yeah.
Because a lot of times things don't make it all the way to a court case, and so you pretty much just have to look at a settlement and try to figure out what your best practices should be based on that item.
And sometimes the settlements are rather large. So when the National Federation of Blind sued Penn State University, it never went to trial. But the settlement language here, which I copied down here, They promised to implement a strategy to make all electronic information technology systems used on its campuses fully accessible to blind students, faculty, and staff. So that's their kind of standard by which they were going to go forward. Now, again, they probably use the same types of laws and best practices that we use for that, but that's a broad settlement, right? So.
And sometimes the settlements will specifically specify what, like WCAG level you have to be at,
Yep.
or other very specific, not in streaming media specifically, but I know there was one settlement with an educational institution where it specified hiring a new staff member to take on a particular role, the Berkeley one.
That was the first Berkeley
Scanning,
standard,
yeah.
yeah. So in, we're gonna get to that, right?
We're gonna get to the second Berkeley.
Oh yeah, we're gonna set this Berkeley, sorry. So the first Berkeley scenario, they actually have to create a job in the library,
Yeah.
I think. So budget, the provost decided this belongs to the library, which makes sense, again. A lot of what we do can be transferred easily to the library function. And so they had to come up with a job, and this job was part of that first settlement, saying you have to create a position, and that position will do all of that work. Still, that seemed like a lot for one person.
Yeah, for sure.
Of course, you're nothing unless you have multiple roles in any good library today, right? But conceptually, so, next question. You drive some common practices in media accessibility. I think we kind of did some of that. Certainly the most common practice was the standard probably mentioned, which is being updated soon. In general though, does everyone here have a program on their campus or at their institution where they deal with accessibility? Let's see some hands. So about half, okay, good, all right. And I'd just be curious, do you think that the job is getting done well? I'll take a giggle. I find that certainly, I don't know if that is ever, performance is ever measured well on campuses. So we may have common practices, but I'm always about whether or not the common practices are actually meeting the needs of our users. And this, my eyes were opened about 5 years ago when I had in my legal research and writing class a student who was blind. And so I was dealing with the fact that her JAWS program couldn't read Westlaw and Lexis, at all, it skipped through stuff. And that the publishers in the textbook case were giving me real trouble on this. So I just started scanning and doing it. And so the only way we can really know if we're meeting the expectations is asking the users what they need and giving them accommodations where necessary, even if it may be over and above what could be a common or best practice.
Yeah, I think a really valuable way of building this sort of program is to build a relationship with the office in charge of this at your campus, specifically so that they can put you in touch with willing students who will answer questions and provide feedback. Because too often, I think it's done in a vacuum rather than talking to users.
Absolutely, please, go ahead.
I was just saying, one of the things that we may not have any control over, but which I think feeds into that, is the fact that the students have to self-identify.
Right.
And so we may be aware that there's a student who can't use something, but we can't say, hey, you don't seem to be able to use that.
Yeah, they have to be authorized by the entity on campus.
Right, well, and that entity can't seek them out. They have to
Yeah.
seek the entity out. And I think that it means that it behooves us to make everything accessible with the assumption that there are people who are not doing this.
And also, I think it means that it's very valuable to advertise what you have to offer on your website, even if it's only for authorized people, and explain how they can become authorized. Because somebody with a disability might think that there are more disadvantages to self-identifying than advantages, depending especially on where they're coming